Good evening and welcome to the Tuesday edition of the People's Show's Legal Hour with your host, Mark Wallace. Let me get myself together here. Oh boy. Yeah, hang on. Okay, you all have to forgive me. I have having some technical issues here. All right. Okay, all right. Here we are. Okay, I am here. I'm here. All right. Sorry about that. Listen, it's the Tuesday night edition of the People Show. It's here with your host and your facilitator, Mark Wallace. Thank you all for tuning in to the broadcast. Coming in just a few minutes. Joining me for the hour is going to be Cook County Circuit Court Judge Leonard Murray, who is going to be taking all of your legal questions. And all you have to do is type in your question in the legal chat, whatever your question may be, and I will read it off to the judge, and the judge will answer your question. So I'll read your name and your question off to Judge Leonard Murray when we start that discussion, and he will answer your legal question. Now remember, the judge is a current sitting Cook County Circuit Court judge, and he cannot give you legal advice. But what he can do and will do is answer all of your legal questions that you may have. So please type in your legal question in the chat, and I'll read it off, and the judge will answer your question. I'll read your name and your question. All right. So thank you very much for tuning into the broadcast, and I ask that you please support us by joining our YouTube page and making sure that you become one of our subscribers. There is no cost to subscribe. We are not monetizing this program. We're not doing this program for profit. I am doing this work as my civic engagement and hoping, and my aspiration is to get more of us connected collectively, building our own independent Black independence, our own independent Black voting bloc, so that we can address socio-political and socio-economic conditions of our communities. And the only way that we are going to do this, the only way that we're going to do it is that we must organize ourselves together. Now, what we have not done is organize ourselves to be institutionally connected. And so here in Chicago and Cook County in the state of Illinois, we are working so that we can build the largest, most powerful, independent Black voting bloc in this region, so that we can make sure that the issues that are important to elevating and thriving the Black communities are addressed. That is what our sole purpose is. And the way that we can do that is by making sure that we take control of our voting power, in that we take control of those who are in the offices that belong to the public. That's why they're called public offices. They are public officials. They're not private officials. They are operating as private officials because there are single, large, wealthy donors that are buying politicians. And they're only able to do that because we don't participate in the electoral process in a strategic way that empowers us to take back the power and put the power in the hands where it belongs, and that is in the hands of the voters and not in the hands of a preferential few. That is the purpose of building 10 by 10 to win, which is the independent Black voting bloc here in Chicago, Cook County, and in the state of Illinois. And hopefully that will be a model that we can take to another level and go across our state lines and become a national model for making sure that our Black voice and vote is institutionalized, that we organize wherever we are in this country. That is our purpose. That is the mission of this program. That is the mission of the People Show. It is not the mission of the People Shows to become a profit center. That's not what it is. It is to become a politically engaging and educational and a collaboration effort. That's what this program, The People Show, is all about. That's exactly why it was called The People Show when I started it 14 years ago, and that's exactly what it is today. All right, we're going to get started and get into our conversation. I see that Judge Murray is in the green room. We're going to be bringing him on in just a moment. So again, if you have a legal question, please type it into the chat, and I will see your legal question and I will read your legal question. Now, you have to be on one of the forums. You have to be on Facebook, and to have it streaming, the StreamYard on Facebook, in order for you to get your question viewed. So please write it into the chat, and then we will be able to see your question, and then I will read it off to Judge Murray. All right, so joining me now is our weekly guest, is Cook County Circuit Court Judge Leonard Murray, who's the supervising judge in the I like to call it the real estate housing division, and for safety and all those other issues. So if you have some issue with safety and real estate, and you're in building court, chances are you're going to be in front of my great friend and good friend, Judge Leonard Murray. Judge Murray, welcome to the program.
Good afternoon, Mark. How are you?
I'm doing just great. Hold on one second. I think that I'm having some issues here. Okay, there we go. All right. I didn't have my headphones connected so where I can hear you. So I got you now.
All right.
All right. Okay, so last week we left off and we were talking about the election of the mayor in Markham, who was someone who was a felon who had run for public office, gotten elected or won the election. And after he was elected, there were people who were trying to say that he was not eligible to be seated. He then went to court and they ultimately prevailed. And so we left off talking about that, and you were going to provide us with some information on what happened in that particular situation.
Yes. Well, to begin with, I think his name is pronounced Ekpawa.
Yeah, it's something like that.
Yeah, I've never heard it pronounced. I wasn't clear about it. In any event, this all initially begins back in 2017 when he was a candidate for election to the mayor of Markham. And he prevailed in that election. The current and then state's attorney, Kim Fox, filed an action in what's referred to as quo warranto, which essentially challenges the authority of a person to be eligible to hold a position, an elected position. And in that lawsuit, she also sought a declaratory judgment with respect to suggesting that he was not eligible to hold the office, and then an injunction to enjoin him from taking the oath of office. So she prevailed in that lawsuit, and ultimately on appeal prevailed as well. And because of that, Mr. Akpawa was not able to take the oath of office and assume the position. Now, it seems that after that, he was uh, challenged in a subsequent election um, by a different group of, in administrative context, by a group of objectors who said that because of his felony conviction, federal felony conviction, he was not able to assume the office. Um, that electoral board overruled the objection, deemed him eligible, and ordered that his name be placed on the ballot. Uh, the objectors, having lost that at the administrative level, then filed a petition, or at least a legal challenge in court, suggesting that the electoral board's ruling was incorrect and should be reversed. Um, they lost that challenge, and then on appeal, that appellate court reversed the trial court and the board and deemed that he was ineligible. Now, it seems that somewhere along the way here, he was able to get then Governor Rauner to issue a restoration of rights. Uh, Now, what's important to realize here and be clear about is that uh, it was a federal conviction involved that was the reason that he was deemed ineligible. Not a state court conviction in Illinois, but in fact a federal court conviction. So, of course, the governor of Illinois has no authority to effect a federal conviction. He has no pardon authority or any other executive reach relative to that federal conviction. But apparently, what he does have is the ability to restore. Well, we'll get to it, I guess. But he has this ability under state constitution to restore rights to parties who are under the burden of having been convicted. Um, that occurring, Mr. uh, Akpawa, pardon me, uh, then filed a motion in circuit court to undo the judgment that then lay against him, deeming that he was ineligible. Um, this is in the first case. He uh, that ruling was reversed, and then an appeal was taken of that. The appellate court then uh, overruled both the board and the trial court and deemed that he was not eligible. And that case then was taken up by our Supreme Court, who ruled that because of the grant of restoration of rights by the governor, then governor, he was in fact eligible to run for public office uh, because that burden of the conviction, federal conviction, was no longer a taint to his candidacy, and no longer could he be declared ineligible to run for office because of that restoration of rights. So it was an interesting situation of tosses and turns with respect to the Illinois political landscape because of what occurred. Now, how it is that he was able to obtain that restoration of rights grant by then Governor Rauner. The case law really doesn't speak to that. I couldn't find anything uh, in either social media or public comment about why he took that action. But in fact, he did. And as a result, Mr. Akpawa is currently mayor of Markham.
So, is he mayor of Markham because the governor took that position or made that decision? And did he make that decision before he ran, or did he make that decision as a result of
After
a court case?
it was after he ran. So the initial run was in 2017,
Hmm.
and the result of that litigation, it was not taken up. The appellate court there uh, affirmed the underlying ruling by the trial court because there was no administrative proceedings relative to that first run. There was no objectors petition filed deeming him ineligible before whatever the electoral board that would have been formed to deal with objections relative to that election cycle. This was all post-election after he had won. And it was this quo warranto proceedings initiated by current state's attorney Kim Fox that resulted in a favorable order relative to that litigation. Um, but it was then after that he was able to obtain this restoration of rights document that was uh, executed and created through the governor and then filed with the Secretary of State as apparently an official state of Illinois record.
So if he had been convicted of a state crime, would the outcome have been the same, or would there be a different application of the law?
I think it would have been the same. Um, the statute does not speak to the laws in place dealing with the situation. Don't make a distinction between a crime or conviction that is under state law or federal law. It just talks about conviction of a felony, and the act for which he was convicted after a plea was mail fraud. And I believe there was no time served. He was given probationary period. And I can't recall the length of it. I think it may have been 3 or 4 years, but I'm not positive about that. But somewhere in that area. Um, but it was a federal conviction, and the the language in the statute, uh, applicable law, makes no distinction between whether the conviction is a state court conviction or federal court conviction.
Okay. Um, so is this is this ruling um, is this ruling specifically for the village of Markham, or is this a state ruling?
I think you now have to consider it to be the law of the land in Illinois. Even though, of course, the parties involved were individuals involved in the election process in Markham, but I think the language in the Supreme Court opinion would apply to anyone who's in their circumstance, if in fact they are granted this restoration of rights, such as uh, Mr. Ekpawa
Mhm.
was able to be granted.
Yeah, we'll have to find out what is the correct pronunciation of his name, because I think it may be Apawa or whatever it is, but that's one of the kind of sticking points for me, is to be able to correctly pronounce or understand correct pronunciation of someone's name.
Yeah,
Um,
I agree. We all should try to do that. I've just never heard it. So I'm reading through the case. I was
right.
saying, I wonder, what's the correct way to pronounce the name?
Yeah, I have to watch one of the story that was done, because again, I only heard it during that time, and I probably should have done that homework prior to the program. However, but I think the key issue here is it being applying. It may be the law of the land, but the key issue is for anybody else who may have been convicted of a felony, whether it be federal or whether it be state. What's key is whether or not they have received restoration by the governor. I think that's the would be the key. So, just anybody, just because they had a felony, wouldn't be able to use this argument. I would think they wouldn't be able to use this argument if in fact the restoration by the governor had not been granted.
Yeah, I don't think there is any automatic restoration of rights following the type of conviction uh, that is spoken to in both the Constitution and the statute. Um, so of course, there's some states that have a number of different rules that pertain to restoration of voting rights following a conviction after a certain period of time.
Mhm.
And in fact, you hail from Florida, so you know what's going on down there with folks who had served out their sentence and would be otherwise eligible to vote, but for the fact that they have not paid the fines associated with that conviction. So, as I understand it, that continues to be deemed a bar against restoration of voting rights. Uh,
Yeah,
uh,
this was a um, uh, I don't know if this was an amendment after, in fact, they had been given the right to vote, that the legislature took this up and said, well, wait a second, they haven't completed all of their sentencing because they haven't paid all of their restitution, nor have they completed their probation. So until they have done such, they're ineligible. And
yeah,
that impacted over 1 million people.
yeah, they're still under the effect supervision of the court.
Right.
Um, but I don't know what Florida law is relative to a person having been convicted of a classified crime, being able to run for public office. I'm not sure what those rules are, but Florida does have those rules in place that say until you are both beyond probation and also have made restitution, uh, are your voting rights restored?
Right.
Uh,
Right. Okay, I think we have Ashley Johnson who has several questions. So we're going to start with the very first question. So Ashley Johnson's question says that real property is taxes, but personal property is exempt. How is it that landlords are charging rent off their personal property that is exempt? I think that she's saying real property is taxed rather than taxes. So real property is taxed, but personal property is exempt. How is it that landlords are charging rent off their personal property that is exempt? I'm not sure that I understand the question.
I'm not sure I understand it either. The Illinois Constitution, it's unconstitutional in Illinois to tax personal property.
Hmm.
Um, but it sounds like she's suggesting that how are landlords permitted to receive rent for or payments for the use of personal property? Um, uh, of course, from an tax standpoint, that revenue is subject to be taxed for income tax purposes, but not taxed because of the ownership of it. Um, and of course, um, you then would be permitted to uh, avail yourself of whatever deductions are available given um, your enterprise of renting personal property. And of course, personal property is everything that's not real property. Um, so I'm not clear on the question. Maybe she could um, clarify what she's driving at there because
Right.
it's not clear to me what she's trying to get at.
Yeah, Ashley, your question is there's some real ambiguity in your question, so we're not very clear on it. So maybe you can clarify what it is that you're asking. Are you asking if your landlord is charging you rent for personal property that you're using that belongs to the landlord? Not sure what the question is. If that is the question, please clarify that for us so that we can make sure that we address, or that the judge can address that question.
Yeah, because
I'm not sure.
if it's a furnished apartment, then of course the appliances, refrigerator, stove, washer, dryer, those sorts of things, that is personal property. But typically, there's a flat amount that you pay for the rental of the unit, and the appliances are included. Um, so I guess you could argue that they are receiving rental income for personal property, but there's nothing wrong with that. Uh, but if you ever rent an automobile from the various rental car companies, that's personal property, and you best well believe that they're going to charge you for the use of that vehicle.
Right. For every bit of it. Well, and again, I want for her to clarify a question, but
Yeah,
also, I've never heard of a landlord charging rent separately for appliances and that sort of stuff. I'm a landlord. It's never
yeah,
come up
yeah. I
in
have
my
not. I'm
20 years
not
of
either.
doing it.
Yeah,
However, that being said, if landlords choose to furnish an apartment with furniture, I would guess just like any other um, furniture rental facility or rental company, they could charge you rent for that furniture on a monthly basis, which is also personal property. So I'm not sure if that's what she is alluding to, but I would like to. Um, she says which has been exempt since 1969. So I'm not sure. So let me just go to her second question that she says, why is the employer's identification number on the W-2 form? The person who applied for the EIN is the responsible party.
well, it's the W-2 and/or 1099 that could be issued to someone who receives I think the threshold amount is $600 or more for 1099, if, when it is not an employment situation. Um, it's really just record keeping and also to associate the source of the income. You may or may not be surprised that there are folks who are not on the up and up. And there are situations that I'm aware of where tax preparers have in fact created a W-2 for someone and filed it in order to recover a tax refund, only to be later discovered that it was all fraud involved. So in order to determine the source of the income, the employer's EIN number is required in the form that the IRS designs in order to uh, report wages and also 1099 income. In fact, it's not just in the employment context, but if you are fortunate enough to have a bank account that generates interest, uh, that the source of that interest income also reports on a form, a 1099 form, and their EIN number is disclosed there as well. If you are also fortunate enough to have uh, investments in the stock of companies, um, likewise, their EIN number is disclosed on the 1099 form that they uh, distribute uh, in connection with their activities and dividend income that they may have paid you during the year, in a partnership. Um, um, which of course is not an incorporated entity. But if you're a partner in a partnership, whether you are a general partner or limited partner, uh, the realization of income or the activities of the partnership, that K1 form that is generated each year, the EIN number for the partnership is also required to be disclosed. So it's not just employers; it's uh, every entity involved in the enterprise of capitalism in the United States government that's required to uh, disclose their tax number on any form that they issue related to an income source.
Right. So, and you have, this is actually a split answer here because her question is a split question because one, she refers to a W-2, which is an employee, an EIN number, which is a self-employed um, entity. So those are two very separate uh, uh, entities there. One is an employee, and the other is a um, independent contractor or a independent company, another entity. So the employer's identification number on the W-2 form is really an identification number. So that has to be assigned to a particular corporation or a company that has to be identified by the IRS. Um, and her final question was, why do we sign arbitration when that's against the human rights under life, liberty, property, which has been exempt since 1969, according to her question. Not sure what that is. Why do we sign arbitration when that's against the human rights under life, liberty, property?
So I'm not, I can't suggest I'm clear on what the point of her question, but if she's suggesting in business transactions, uh, why do some of them require an agreement to seek arbitration rather than litigation if there is a dispute? Um, that's not illegal that contracts have such language in them. Um, uh, that in the event of a dispute prior to initiating the case, you would first seek, to resolve it through sometimes it's mediation, but for this case, she's asking about arbitration. Um, so it is not it's not an illegal covenant that's part of a contract that if there is a dispute, and usually it's defined in terms of the contract, the nature of the dispute. But you would first seek arbitration rather than filing a lawsuit. And the thought is that it's least expensive to have the case resolved through arbitration than it is in a court case. I'm not sure I always agree with that, but at least that's the thought that's out there, that it'll be less expensive to resolve it through um, arbitration rather than litigation.
Yeah. So, yeah, and I would think that companies would try to do to have a neutral third party to see if they can't mitigate or they can't bring to some sort of resolution um, before it goes to, and if they couldn't, obviously the last resort would be that the parties could not agree through an arbitration or a mediation. So at that point, if the parties are not satisfied with whatever that negotiations or outcome was, then they certainly have the resolution to be able to go and um, uh, at the last line of defense by taking it to court and having it decided by a jury or decided by a, um, a judge.
Right, and even once uh, a case has been initiated, assuming it doesn't go against an arbitration provision, many times parties in litigation will opt to try to resolve it through arbitration, again, believing that it's the least expensive way to do it, and also you may be able to resolve it quicker, claiming that the courts are backed up and can't get the cases as quickly as you can through an outside arbitration uh, approach. I don't necessarily agree with that. I think courts can be as efficient and certainly less expensive than paying an arbitrator to be involved in resolving a dispute. You know.
Yeah, it could become more expensive because if you're paying an arbitrator to resolve it and they don't resolve it, then the next line they have to go to a court. So that's another expense that's going to be added on to whatever that expense was, rather than taking it to before a court and allowing for it to be um, argued and decided by the court based on the law. I think that's,
Yeah.
you know, yeah. One of the questions that she's asking is that um, is it? I think she's asking, is it legal for a company to determine that whether or not they will hire you based on your willingness or not willingness to sign um, that you will that you will go to arbitration if there become a dispute.
Mm.
So. Um, So if she doesn't sign it, or she's not willing to sign, or they're not willing to sign it, is that legal that the company can decide not to hire you if you're not willing to sign um, the agreement to go to arbitration should there become some sort of dispute?
I would think that is not illegal. That such a provision that's a condition of employment because that wouldn't be discriminatory.
Mhm. Right, because everybody would have
Uh,
to agree to that.
have the same option to accept or not. So I wouldn't think that would be discriminatory. And there may be an issue for next week, but I just my initial reaction is that uh, that would not be illegal because it's a neutral provision as to anyone for whom employment is being offered. As long as they're not, as long as everyone who is being offered employment is subject to the same terms. Be you black, white, uh, brown, whatever. Um, so as long as it's not discriminatory, it's probably okay.
Right. If they're only asking for certain people to sign the arbitration and others don't have to sign it, then it becomes discriminatory. If it
Right.
is, if it's not a policy that is a uniform policy that's required by every person who is seeking employment.
Yeah.
Yeah. Okay. All right. Well, Ashley, I think we'll do is the judge will dig more into that to see what the federal standards are and what the case law is or the Constitution says about that. But it appears that if it is uniform, it probably is not illegal unless there has been some sort of ruling by the Supreme Court or Congress has changed um, the law. But we'll find out and we'll explore that next week. So, very interesting question. Um, there was a question that we were talking about earlier today on um, a person getting a citation and not being able to get a copy of that report. Um, and I tried to get more information, but I think I ran out of time, but we're going to explore that to see if we can bring it back next week. Um, uh, but it seems to me that discussion that we were having earlier, that whatever information that a person would need in a report on any kind of violation, whether it be a criminal charge, whether it be a fine or a citation, any type of ticket that you receive from a police officer, there should be a report that you could be able to obtain, a full report on the narrative of what that ticket and why that ticket was issued.
Well, in Illinois, I think we're now either in the second or third year where uh, police contact with the public in the sense of a quasi-custodial situation. Uh, there is data that must be collected by the officer to explain why the contact occurred. And this is all going towards the report that came out several months ago now that highlighted the propensity of minority drivers to be stopped more frequently than others, uh, in their neighborhoods and outside. So that's why the state legislature required the creation of this database to reflect on whether or not these police stops are in fact geared more towards the minority community than the opposite. Um, but it's interesting that the location of the data in actual copies of these tickets is not at the police headquarters. It seems that they are all deposited, at least in Chicago, at Florida West Superior, which is one of the administrative hearing sites the city created probably 20 more than 20 years ago now. Um, to deal with this administrative hearing apparatus that the city set up a number of years ago. And it's also important to remind the listeners that and viewers that Illinois is a home rule state. So under the Constitution, it gives the ability for the local governmental entities, city, towns, villages, et cetera, to create their own rules, ordinances, if you will, that pertain to health and safety within their geographic boundaries. So Illinois, being one of those governmental entities within the state, has set up a rather elaborate system of, of dealing with violations under the city ordinance, uh, which don't necessarily mean that you will go to a state court, if you will, to be heard and deal with whether or not you're responsible. But it's an administrative tribunal. They're quasi judicial, but they're not judges. And I have to convince folks or explain to them all the time that those folks, they're not judges. In fact, under city ordinance, they're referred to as hearing officers, not even administrative law judges. That's not how the ordinance refers to them. Uh, and, and of course, it's very important to know that if you receive an adverse outcome from uh, one of those sites, and I believe there are 4 or 5 sites around the city that adjudicate uh, various types of tickets that one can be issued under the city code. Uh, if you have an in-person hearing, uh, then that hearing officer uh, will adjudicate liability based on what they hear. Often, the writer of the ticket will not be present, so they will proceed by what they call documentation, um, which is a situation where the respondent, property owner, driver of the vehicle, what have you, uh, uh, does not have the opportunity to cross-examine the writer of the citation because they're not going to be there in most instances, overwhelmingly not there. Um, so you just have to be prepared for that situation and try to be persuasive in your argument as to why you should not be found liable for whatever that violation is. The paperwork related to those citations is not at 3500 South Michigan. It's very likely at 400 West Superior.
So if you get an administrative ticket or um, Well, what, first of all, how does a person know whether or not, let's say a police officer issued a ticket? So apparently what you're saying is that police officers, although they issue you a ticket, whether it be a moving violation, and typically at one time when you got a ticket from a police officer, that's referred to it as a peace officer, um, you would go to traffic court, which is held at a state court, not an administrative hearing uh, um, at 400 West Superior. I don't even like to call it a court because it's not really a court. Um, but so now that this rule has been changed at some point, how does a person know whether or not they have an administrative hearing or they actually have a traffic hearing? When do they find that out, or are they noticed for that?
Well, it's on the citation that you are issued, uh, giving you uh, the first date for the matter to appear, and also where you should appear. So, if it is to be handled by administrative tribunal, uh, that is expressed in terms of the location, and also time for the hearing. It should be on the document that you're given at the time of your interaction with the police. Um, Now, if it is a situation, and likewise, if it is a citation for which your appearance is required, uh, the time and place of the initial hearing in that situation, court hearing in that case, should also be disclosed on the citation that would be given to you at the time of the police stop.
So, in well, then in the case that we were discussing, or the um, earlier, so that person, being that they went to try to find out where that ticket was at 35th Street, then that person, that ticket more than likely would be at 400 West Superior.
Right. In fact, that person, because of the location where the ticket was issued, the area, the neighborhood, went to that police station after having gone to 35th in Michigan, police headquarters, told that we don't have it here, but they didn't direct him in terms of where it would be. Um, but we went to, I think it would be the Sixth District Police Station in Inglewood, uh, and was told pretty quickly there that we don't have the hard copy of the ticket as well. And one other thing that was discovered is that apparently, uh, officers who were signed from a certain district are many times working in districts outside of their normal work area, for overtime and other situations. So it may well be that while that ticket was issued in a certain uh, part of the city, the officer may not in fact be part of that district.
But and um, and that officer could be working in that district because they were short staff, and they were calling officers in to do overtime, even though they don't particularly work in that, they're not assigned to that district. Um, but even even if they were assigned to that district, based on, I think, uh, what we're discussing or what you're saying, even if they were assigned to that district and that type of citation was issued, it's still an administrative citation that would not, the records of that would not be held as a typical citation issued or report issued by a police officer because it's an administrative designation.
Yes, because if it is a citation which requires a court appearance, or at least the the option for court appearance, then I believe those tickets are actually handled by the clerk of court.
Yes.
Um, uh, so, uh,
Handled by the clerk of the court, but shouldn't they also go through the police department?
no, as I understand it, they would not be at police headquarters. You would
Okay.
actually have to go uh, track it down at through the clerk of the circuit court to see where the hard copy of that ticket might be.
All right. Um, they can certainly make it a little more complicated for people to try to find out where they have to go.
Yeah, the
Um,
other thing I discovered is the hours at the police headquarters are limited for retrieving those records. Their hours are 8 to 2.
8 a.m. to 2 p.m. Monday through Friday.
Right.
Wow, they've made it a lot easier for people to be able to navigate that time. So, in a sense, they essentially have shut down the ability for someone to get records. I would wonder if that could be an argument for a violation of due process.
It's interesting. I guess if those records are essential to assisting with your defense of whatever the alleged violation is, it could be. But then, if it's a matter in court, the judge could direct the city to produce those records.
Yeah, because the average person who is working a job works from 9 to 5, and they don't have time to go at 8 o'clock because they're on their way to work or already at work. And at 2 o'clock is midday for most people. So it's quite arbitrary. Uh, and it would be a very interesting question uh, to find out why that rule applies, or if in fact, well, I guess if nobody challenges it, then it stands until somebody challenges it.
And I think probably people don't challenge it thinking, well, that's how it is. But when you think
Right,
about it, why is it why is it limited to those hours?
right. What's it? What is the purpose of that?
Yeah, why must
Right,
it be just between those hours? Why can't it be something, as you suggesting, more accommodating to folks who are working for a living?
right. It's like restricting or suppressing access, just like suppressing access to voting. That we have voting set up the way that we have it set up. That it should be voting should be on a day where people don't have to navigate between going to work and being able to cast the fundamental right to cast their vote. And here, when you are being accused of something, you're also being put in this very limited uh, position to be able to defend yourself, to get information to defend yourself. Seems seems quite arbitrary to me.
Well, those who have the superintendent's ear, maybe they can persuade him that those hours should be expanded.
If not, the superintendent could be facing another challenge another way. All right. So, all right. Listen, we have a few minutes left, and we've had a whirlwind of changes. I can't remember if it was Lennon who says that we could go decades and not much happen, um, something like that. And in a week, a decade of things could happen, or something like that. I forget the quote. Um, but in the last 48 hours, we've had a decade of events to take place with the president of the United States for the first time in modern history deciding to step aside and endorsed the vice president, where many people were arguing that the president was just too old and he needs to pass the torch. And of course, the Republicans were salivating at running against their old guy, against our old guy. And in a matter of hours, the entire election has been turned topsy turvy. Now, I don't think that this script was written this way by the Democratic Party or by the president. But I don't think that it could have been written better to position uh, the Democratic Party and Kamala Harris to put the Republicans in a further disarray than they are, because the argument of running against the old guy is now the argument against the old guy on the other side.
It has been. I think you alerted me to the fact that Biden decided to, or at least made it public, sometime Sunday afternoon. Uh,
145, he made the decision,
yeah,
and it was announced at 155.
and it was also interesting that it came after the typical morning, uh, Sunday morning, you know, talk
Yes,
shows had ended, so it couldn't be the buzz. Uh, Doing those shows, although with cable news, that they're on 24 hours, 7 days a week. Um, but it seems like it's totally flipped the script in terms of the bounce that the Republicans might have experienced following their convention. Um, whatever that was, I think it's probably been totally washed away. And now you've got the first uh, African American Asian person running for president, um, and it's just it's amazing. It's the folks are really getting geared up and excited about the prospect of what could happen here. So it is amazing just the change in the direction of the wind in that 1 week.
yeah, in 24 hours, right? In 24
Yeah,
hours, she has raised more money than any other candidate in history. She raised more than $100 million in a 24-hour period. I was on a call. There were 42,000 black women on a call. Black women for Kamala. 42,000 black women, and they raised $1.7 million on that call. I was on a call last night. There were 17,000 black men on this call, and during that call, we raised $1.3 million. And of course, the men were trying to match what the women did, but 42,000 women raised 1.7 million, and 17,000 black men raised 1.3 million. So, in any case, it's very exciting to see uh, the mobilization of and the complete juxtaposition, right, um,
yeah,
of what has taken place in the election. Now,
yeah.
I can tell you, I was completely, um, I was really upset about the process. I was upset that the Democrats could be doing something which I thought was very stupid, giving the sort of the situation that we had with respect that you had this president, and we're going to go over a couple of minutes, but we have this president and the alternative that, and you have a president, you have a vice president situation, and you have the Democrats who were just, you know, and I'm calling it the elite, the elitist, Barack Obama's, David Axelrod, the James Carville and the, David Plouffe, all of those elitists, right? That were calling for the president to step aside and saying that the president couldn't win. Now, that was only coming from the elite. And mind you, all of those people in Congress that were calling for the president to step aside, all of them were white. All of them were white. So there was not any black people that I knew of that was calling for the president to step aside. People down, in the middle, and certainly people at the lower spectrum. So I was very upset and put off by that. Very put off by it because I thought that this was a recipe for disaster, and the Democrats were just kind of, you know, had this like internal combustion. But when the president made the decision, and of course you and I, we were all together on Sunday afternoon, um, and we were still together when that decision was made because when I got home, watching the news, it was all over the news. And then I called you, and I was calling to see because I was certain that there was somebody who was looking at their phone, their cell phones, out at you know at the tennis club. That somebody had said, the president just stepped out. I was sure that had gone viral. And when I called you, that you said you had not heard that, I was surprised because everybody's on their phone, even watching a tennis
Yeah.
match. They're not. But my frustration and my anger turned quickly to excitement that Joe Biden made what, again, a decision that a president would make, right? A person who demonstrated that I know that I would want to do this and I know that I can do this, but in the best interest of the country, I'm going to make this decision that is totally against what I want to do, but I'm going to make the best decision for the country. And in making that decision, we later found out that he had a conversation earlier with um, the James Clyburn from South Carolina, that he had that conversation. And he and James Clyburn had that conversation, and James Clyburn wanted him to stay in the race and allowed for him to make that decision. And he made that decision that he was going to, that he selected Kamala Harris, and that it was unequivocal to him that he was going to step aside and give um, his immediate support to her. He's going to make a statement, and then he was going to give his immediate endorsement to Kamala Harris. And to see that all come together the way that it did, so I was a little bit melancholy, but it quickly went to excitement for the opportunity that we have to accomplish uh, and elevating somebody who is quite brilliant and who was quite involved in all of the major pieces of legislation that was passed by this administration. So she was not like some bystander. She was intricately involved in the crafting of those four major pieces of legislation that is absolutely transformational for working people, poor people, and in particular, uh, black institutions and black people. So, and I think that the level of excitement is just absolutely through the roof um, for what what the potential is. And as you alluded to earlier, or you not, didn't allude to, that you stated earlier, the Republicans are in complete disarray.
Yeah, I don't think I think they really thought that Biden's ego wouldn't allow him to step back and let someone else be the standard bearer for the Democratic Party this time around. You know, this is this would be his last hurrah. And there are folks who thought it would be another tight race, and that it might be possible for him to pull it out. Um, but it just seemed as if things that have happened over the past month or so, beginning whenever the first debate occurred, that there was just an erosion of, of, of confidence in him being able to win. I think. I think people believe he would be able to govern if he won, but I don't think they believed he would be able to win in order to govern.
Yeah, that's where I have real problems. I have real problems with the Democratic Party, with the alternative, with the somebody who is convicted of 34 felonies, found liable for rape, found liable for fraud, hundreds of millions of dollars in judgments against them, and is and still facing other charges. That even if our guy, who has been a transformational president, even if you had, you know, some disappointments in a performance of a debate, when all the national polls said that there was less than 2% change in the polls, if you really believe in polls, I don't. But all of the polls said that there was only been a 1% shift in the polls. Now, the Democrats, in my view, should have absolutely embraced, wrapped their arms around Joe Biden, who is not a convicted felon, who is not a person who's been found liable of fraud, who is not a person who's been found liable of rape. And the Republicans have wholly wrapped their arms around their guy. That to me is where I just had a serious problem. So, but I said, in the aftermath of all of that, Kamala Harris is the presumptive nominee. I'm excited about that, and we have to move forward, and we have to make sure that she becomes the president of the United States of America, which would be absolutely fitting to defeat Donald Trump. Uh, uh, as a consolation, it's the greatest consolation that anybody could look forward to. So, all right, well, we'll watch it all unfold. And next week, I just made a note. Ashley, we're going to look into some of the questions that you have asked, and to see if we can't clarify that for you from a legal perspective. And I think one of your last question was, can we define liberty from an entomology perspective? But I'll talk about that with the judge offline. We can't talk about it right now. But I want to thank everybody for tuning in to the program and joining us for this Tuesday night edition of the Legal Hour on the People Show with Mark Wallace, and my weekly guest, Judge Leonard Murray, who is a Cook County Circuit Court judge of the Housing Division. Judge Murray, thank you very much. Get some rest, and we will talk this week about some of those other issues. I'll look into them.
Okay, thank you, Mark, and
good night. Good night. Thanks so much. All right, folks, we'll see you on, Monday night, next Monday night, for the Monday night edition of the People Show. Have a good night.